Hi everyone, good afternoon. So Ruchi and I will be speaking on the art of reading a judgment. And in basic sense, what we'll be discussing is how to go through a judgment while reading it, how to understand the same, how to analyze the same, and at the same time, how to, in short, make sense of the entire judgment so that you're aware of how to probably use it as a precedent or prepare a case note or use it for general research purpose. So we've divided our topic into some further subtopics. And as in when we move forward with the PPT, you'll be getting a grasp of all of those topics. So we'll start off by telling you how the steps and techniques for reading a judgment effectively. Now, in basic sense, when you're going through a judgment for the first time, as these key points we've put down, if you understand the context, you can identify the key legal terms, you can break down the judgment and then come to the conclusion. Then effectively, you've read the judgment in a way in which you will understand it and make sense of the same. So when it comes to understanding the context as in the point of law or the arguments made or why the case is actually held in the first place will help you in understanding the final decision passed. Now, in the same way, while you're reading the judgment, if there are any cases that are cited on the same topic or within the same judgment, any previous precedents put in, then those always contain useful information and arguments that help you to support or refute your argument. So as you're going through a judgment, you'll notice that there are several precedents argued by both the sides, both the counsels of either side, which there are paragraphs actually put in this judgment itself as a citation, and those are used to basically help argue the case while in court, and then used by the judge while actually noting it down in the judgment too. So that context is basically the factual matrix and precedent of the exact same factual matrix that has been used before and therefore used for help in this judgment now. Moving further, the key legal terms and jargons are actually used in the court decisions. Obviously, it's helpful to understand them when you're trying to read through a judgment. And in case if you find a term that is unfamiliar, which very often happens either because there is unnecessarily fancy English language, or it could be a lot of legal jargon put in. So if you're unsure of what it is, it does make sense to research and understand its meaning before going further. Otherwise, it will not make sense, and moving further, you're not going to understand the entire judgment clearly. Now, when we say breaking down the judgment, we mean in simple terms if you can break it down into smaller components. Ruchi will actually be going through the elements of a judgment in entirety, which is these components itself. So we'll keep this part for then. It will make more sense at that time. And we also show you an actual judgment from which we'll show you points of these things. And then coming to the conclusion, this is a way in which you can get an overall summary. In fact, very often you'll notice in court, there'll be a counsel reading a judgment and they'll go right to the end and read the last few pages and then they'll go to the facts, because what comes at the end is the conclusion and the actual decision given, which is more of a summary of the entire, not factual matrix as such, but at least the point that has to be addressed. So effectively, if you're trying to read a judgment in a fast manner or trying to make sense of what it entirely says, probably if you read the conclusion first, you will know what has already been decided. So then going through it will be a little easier flow.
So now, as we all know, that judgment is a very important source of legal knowledge. Also, it can be very tricky at times to understand or to get a comprehensive understanding of what the judgment actually says. So it is very important that we know what are the different components or elements of a judgment. Now, if you see the slide that we've just shared, it has the several components which a judgment usually has, and all the judgments that you go through will have all these points for sure. So the first is the caption of the judgment. By caption, I mean the name of the parties, that is Tushar, Ranglidas, Notaria, and others, who are the applicants, versus MCGM, who are the respondents, and others. So in every case, there'll be a caption. So this caption either will have X versus Y or A versus B. So this, and also the court in which the case has taken place, the quorum, this entire part is referred to as the caption. Now, this is the very first thing that you will notice in any judgment when you are reading a judgment. So now for different types of cases, for example, in civil cases, you will have the name of the parties as plaintiffs and defendants. For criminal cases, you will have a complainant and the accused. And if supposingly you're reading the judgment of an appeal, it will be appellants versus the respondents. So that entire thing is called the caption of the judgment. Now, moving forward, the next is the case number. Here, if you see, the case number is Notice of Motion lodging number 318 of 2019 in writ petition lodging number 2645 of 2018 with writ petition lodging number 2645 of 2018. Now, here in this judgment that we've pulled out, there are two writ petitions which are tagged along. So this is called to be the case number. Now, generally, when you're filing a case, the registry will give you a lodging number. After you've removed the objections raised by the registry, you will get the final number. Now, it becomes very important to know the case number, since if while researching or analyzing the judgment, or if you want to prepare a case note of several judgments, you will have to look for the judgments by this case number if you want it directly from the Bombay High Court website or the Supreme Court website. So this is a very important element. And you'll also come to know the year in which the case was filed. Now, moving forward, the next is the case citation. Now, the case citation, as here you can see, is 2019 Supreme Court Cases Online, Bombay 1798. And it is also, so there can be equivalent citations as well. Here in this case, they've given All India Reporter citation as well, which is 2019 6 AIR Bombay Reporter 16. And similarly, there's one more citation. So now, as we all know that while we are reading judgments or while we are researching, there are several law reporters available in India. For example, you take All India Reporter or Supreme Court cases. You can also research or look out for judgments online, and SEC Online has a separate way of citing judgments. So now, if you see the very first citation, 2019, the first thing that you can see is the year of the judgment. SCC Online is the name of the reporter, and 1798 is the page number where the judgment is referred, or where you can find the judgment. If supposingly you do not have access to any of these Manupatra or Supreme Court cases, then you can probably go to the High Court library or to any library where all the books are available. And if you see the second citation, AIR of AIR, All India Reporter, the first element is the year 2019. Then 6 is the volume number. AIR Bombay is obviously the reporter, and 16 is the page number. So when you're pulling out a case from All India Reporter, you have to pull out the All India Reporter of the year 2019. There can be several volumes to the year 2019. Therefore, this is volume 6 and page number 16. So in order to find this very judgment, which I am referring to, you have to first see what the year. So the citations also have several sub-components, as I already said. That is the year, it can have the volume, it can have the name of the reporter and the page number. Next important element is the bench and the quorum. So here, as you can see in this judgment, the quorum consists of Justice G.S. Patel before the Honorable Bombay High Court. Now, similarly, in all the judgments, you will find quorum. Now, the quorum can be either of a single judge bench or a division bench. Now, why this is important is because when you are supposedly reading a judgment of a single bench and you are supposedly finding a judgment for your appellate case, so a single judge bench judgment will not work where a division bench has to give a ruling. It obviously will have a persuasive value, but then if there is a judgment overruling this, which is of a division bench, then you can use that. So that is why quorum is a very important part, and you must pay attention, because a lot of times if you're using a similar kind of judgment before the bench, which has, the similar aspects of law, and the quorum is known, then it makes a lot of difference. The next point, the next element of a judgment is the procedural journey of the matter. So procedural journey can be anything but the background of the case. So basically, when you are reading a judgment, the first paragraph or the first initial few paragraphs will be how the case has traveled. Say, for example, if you are reading a judgment of an appellate court, the judgment will have the first paragraph as from where the judgment has arisen or from where the case has been filed. So, for example, if you are challenging a case which has been filed in National Company Law Tribunal and you're reading a judgment of National Company Law Appellate Tribunal. So the first paragraph will say that this case is arising out of an order dated so and so from the National Company Law Tribunal. So this is how the case has traveled from lower court right up to the Supreme Court if you're reading a Supreme Court judgment. Now, the procedural journey, you will also find types of claims in the first few paragraphs. That is, supposingly, if you're reading a civil case, then in a civil case, you will find in the initial paragraphs if it is a property dispute or a money recovery. Now, generally, not here, but generally in the reporters, you have a case note or a head note. If you don't have sufficient time, then maybe you can go through the head note and see if the case that you're looking for or that you're researching or you want to cite is relevant for the and is serving the purpose that you're looking for. So just having a brief background and reading the head note will make you understand what the case is about. Now, the next element can be description of parties and facts. So description of parties will be what the plaintiff is. Supposingly the plaintiff is a company or the plaintiff is an individual. So the judges, now this is not found in every judgment, but in most of the judgments you will find this, because giving a description of the judgment of the parties, will tell you who the plaintiffs are, who the respondents are. Now, several times there are a lot of respondents, as in if you're seeing a case which has 8 respondents, then the judgment can either define or describe either few respondents or all respondents. The description of parties will give you the party who is initiating the judgment, initiating the legal proceedings, or the party who is defending the legal proceedings. The next element of a judgment is facts. Now, this plays a very crucial role because when you're the facts, when you're looking for a judgment, the facts can be different for each judgment. And the facts may not be similar, but maybe the point of law that you're looking for is up to the mark, like is appropriate. So therefore, it is very much important to first read the facts, and while you're reading facts, you don't have to skip any part of the fact, because there are some crucial facts which play a very important role later when you read out the reasoning of the judgment. So therefore, now facts can be, while reading a judgment, you have to identify what material facts are, because for judgments like Keswananda Bharti, which runs into several pages, you cannot keep reading the entire body of facts, because now this is a very important technique. Now, and also the judgment will not obviously cover all facts, because in supposingly a suit, the plaintiff has given facts in the plaint and the defendant has given his part of the facts in the written statement. So, but the judge has to analyze and put only those facts which are material for deciding that particular issue. The next point is contention of parties or submission of parties. Now, very often when you're reading a judgment, you will find that in later paragraphs after the issues or maybe before the issues, that it starts as it is submitted by counsel for the applicant, it is submitted by counsel for the plaintiffs. These are the legal submissions or the submissions made by parties relying on which they are putting forth their case. Now, in this part of the judgment, you will often find legal provisions, you will find case laws which the parties are relying on. So these 3 elements like contentions, issues, and case laws are all based on the legal provisions. Now, contentions are the arguments Now, if supposingly I want to state one fact, to support that fact, I will argue with help of legal provisions. The next is issues. Issues is can be defined as nothing but if a proposition which is asserted by one party and is denied by another party, that gives rise to an issue. Now, issues can be of fact and issues can be of law. Now, it depends on what type of judgment you are reading, but issues of law are most important, because when you are citing or referring to a judgment, the issues of law and the reasoning given will help you to determine whether that particular judgment is useful for your case. Now, issues of fact also can be important if supposingly you have found a judgment which has similar facts. So, if you place such kind of a judgment before the bench or before the court that you are in, then it plays a very persuasive and a very binding force. The next element is case laws, application of law. Case laws basically are precedents or judgments which are decided by courts of law and which have been used endlessly. Because, for example, there can be a point of law which has been decided several number of times. Now, case laws can be placed by both the parties. While going through a judgment, you will find the contentions and the case laws which are placed by the parties. Also, while arriving at a conclusion, the judge also may refer to case laws or may give reasoning for why a particular case law cited by a party or referred to by a party is not relevant or is relevant. So, supposingly, if case law that is stated in a or that is referred to in a case which you are arguing or in the judgment that you are referring is completely different from the facts that you have in the present case, then that case law will not be applicable to you. The application of law similarly is applying the provisions of law. Therefore, it is very important when you're reading a judgment, you have the bare acts or the provisions of law along with you while you're reading the judgment. So, in this element, that is application of law, you will find the provisions of law. For example, in the case that I was referring to, the judge had cited section 354. It cannot be visible, but as you can see here, the second paragraph states that the writ petition is under Article 226 of Constitution of India. Now, while going through this judgment, if you don't know what Article 226 of Constitution of India is, you should immediately open Constitution and refer to that relevant provision. The other section is also section 354 of MMC Act. Now, this was a very classic case. That is why 354 was also cited further in the paragraphs. So therefore, application of law becomes very important, because when you're reading a judgment and looking for a judgment which is on the same point of law, and you see the provisions which are similar, you get a context of what you're looking for. Now, last but not the least, there are two elements, most crucial elements of a judgment, which are the ratio decidendi and the obiter dicta. Ratio decidendi is nothing but the final verdict that the judge has given, the bench has given. Now, the final verdict can comprise of what the final decision of the court is after a scrutiny of all the facts of provisions of law, after hearing both parties, after taking into consideration the evidence that has been laid. In the final verdict, you also have to see, because in several cases, you will find that there is a 3-judge bench supposedly. Now, there can be one judge who is dissenting to the judgment and 2 judges who have a similar opinion. So, the final verdict will have a majority rule. So, if two judges are in favor of one judgment and one judge is dissenting, then obviously what the 2 judges have decided will be the final verdict. And final verdict is basically the determination of rights. So, for example, if there is a property dispute, then what would be determined is basically the title or mean profits or etc. And obiter dicta, it will be the opinion or the observations of the judge. While you're reading the judgment, you will find several statements which are not findings, but they are observations made by the judge, or they are a kind of not findings, but the statements given by the law. So obiter dicta plays a very important role at arriving at the ratio decidendi. Ratio decidendi will also have the reasoning for the judgment. Now, while you're going through the judgment, it is very important to recognize these different elements of a judgment, because firstly, as I said, when you recognize and bifurcate these elements, it will be easier for you to skim through the judgment very faster and in an easy manner. So the first thing is the legal claim, that is what the party is looking for, what the party is seeking. And this is the statement that establishes the legal relationship between parties involved in the dispute, sets out what each party is claiming. So for example, you are claiming money in a money recovery suit. So that would be your legal claim. Then, as I said earlier, the facts of the case are material propositions and those bundle of facts which determine the reasoning. Now, the reason why I said it will not cover all facts, the judgment will not cover all facts, is because the judge has to cite only those facts which will be valid for his reasoning of the judgment. The reasons of the judgment is the next point, which means that after going through the provisions of law and after having gone through all the cases that have been cited, the judge is supposed to give an explanation for him to arrive at a particular judgment. So reasoning will contain of this explanation, and it will also have, it outlines how each party has presented their case. The next is the disposition, which is the final verdict. Now, final verdict in case of criminal matters should also have the quantum of punishment. And in case of civil matters, it should have the costs involved. So the costs which you find in a judgment will be like a breakdown of all those things which are associated with the judgment, like legal fees or any other costs incurred. By understanding and going through these elements of a judgment slowly and with a calm mind, you will be able to analyze the judgment in a better manner.
Okay, so moving further, we'll be talking about the challenges that might be faced while reading the judgment and how to actually overcome them. So, as Ruchi explained, each and every element within a judgment has to be kept in mind and at the same time understood to actually make sense of the entire judgment as one like comprehensive reading. So, initially, as we've written in the first line itself, reading a judgment can be difficult, especially if it's complex and lengthy. Now, assuming that there are mostly law students in this platform, usually when you get even a simple case note to prepare or a case brief to prepare or that IRAC format to prepare, what happens is you first try to look for a judge if it's given to you as a like assignment. More often than not, what a student would do is they'll try and look for a small judge. Small meaning not too many pages, not lengthy. And that is assumed that since it's not lengthy, it won't be complex. But at the same time, having a smaller judgment, having a lengthier judgment might just mean that there are a lot of legal provisions involved or a lot of precedents actually there and not necessarily very complex, to be honest. But in any case, the challenges that could actually arise would be one, understanding the legal terminology involved, two, keeping up with the court's arguments and decisions, and three, like actually struggling to stay focused while reading. Now, very honestly, if you're going through, say, as she said, Keshav Nanda Bharti case, for example, that matter is pretty lengthy. And if you're going through the entire thing or any recent judgment which has come, which is probably like even 50, 60 pages, it does happen that while you're going through it, you actually lose focus or you feel that it's not making sense to you. So basically keeping in mind the elements that we said before and also having one, a calm mind, and two, understanding what you are trying to read will help you make sense of it. So ways to overcome it as such, which we've noted down are, you can take notes while reading it, as obviously in general, taking notes will help you remember better. By the time you reach page 30, you shouldn't forget what was on page 10. So if you probably made a note, you might actually remember it better, because in a judgment, you can see very often that the facts are given right at the beginning. Then the legal provisions are given. The citations are given from before. And then in the final order that's being passed, the judge refers to all of them together. So having a note made may make it easier for you to actually not need to flip through the pages again, but know what exactly is being said. Next, you can break up the text into smaller sections so that it makes it easier to understand and comprehend each part. Now, this doesn't mean a 30-page judgment you break into like five pages each, because that would be actually studying a chapter, not studying a judgment, because the judgment would have to be read as a whole. Only then you'll be able to make sense of it. But when we say breaking up the text into smaller sections, it means the elements that Ruchi went. Like you read the facts at one point, you can read the cases cited at one point, the arguments made at one point, probably try and find out any of the obiter dictas in the middle, and then go to the final verdict at the end. So that is a way in which you can break down the judgment while reading to probably make it easier for you to go through it. Then, of course, reading it slowly and carefully will help you in understanding the judgment. Obviously, with time, you will end up skimming through judgments very fast because in actual litigation practice, you'll realize that most of the facts involved are not that necessary. We're not saying they're not necessary, but not necessary in the sense that if you're just using it for one particular point of law, then if that point of law is there in your final verdict, that judgment has precedential value. You don't have to find an exact judgment with the exact same facts because very often that might not even be the case. There will be similar facts, but the exact same dispute happening like many times may not be the case. But having a value, if the rule of law held or a similar factual matrix has been held in a particular way, then that becomes your precedent, which you use further. After that, you become familiar with the legal terminology. You can actually use a dictionary or any other resource to look up unfamiliar words. Now, this is going back to what we said before also, that if you're reading a judgment, a challenge obviously is your legal terminology if you're not understanding it. So it's best to overcome that challenge by actually knowing what you are reading. Then having access to case law summaries and precedents can help you understand the details of the judgment better. Now, this can be in two ways. One, if you're actually doing case research, for example, like you're writing a research paper or something, then you would obviously look at multiple judgments to try and figure out your point of what you're trying to make. But if you are looking at precedents in the sense that you are trying to figure out a particular point of law, and if you're going through 3, 4 judgments together, you might see one final judgment of, say, a Supreme Court, which actually makes use of all the other 3 judgments. So, in that sense, now your one particular judgment copy will mention paragraphs from the other 3, but it won't mention the entire judgment, of course. So, in this sense, what we mean is case law summaries and precedents. Each case is important, but if particular points of that case is taken and put in another verdict, a few like further verdict in the future, then of course the previous verdict has more value and is a set law in that sense. In that sense, also the last point that we've actually put in is if you actually have an experienced legal professional with you to understand the language and context of the judgment. So in that sense, basically, this can be either your teachers in school, this could be an assistant or associate in the place you're interning or working at. This could also be any senior that you know or like is in the profession. Now, this goes back to our basic school concept of if you not understand, you ask. And it's the same thing over here. You need to seek assistance from any person if you're not understanding what the judgment actually is saying. Instead of trying to figure it out yourself and just go on reading it. Because, see, very often, if you type a case name on Google, you might get 100 research papers on that same judgment. Many people would have written what this judgment is, written a case brief on it. But even if that doesn't make sense, or for example, by chance you see it's written differently in 2 places, you may get even more confused. So in that sense, if that is the situation, then of course you can approach somebody who's actually dealing with these on a daily basis. And just to go back to the fourth point of how to overcome the challenges, Ruchi will give a few examples of legal dictionaries that can actually be looked at to find out unfamiliar words.
So, for example, while reading a judgment, you come across a legal term which you're not aware of. So, then you can refer to legal dictionaries like you have lexicon, law lexicon, or you have Webster's. So, all these dictionaries will help you give a general idea of what the term means. Also, when Yazad said that you should have case law summaries with you while reading a judgment and precedents, which will help you better understand the judgment, of course. So I would just like to cite an example. For example, the IBBI website has a lot of summaries of the landmark judgments, and they have provided it in a tabular form. So instead of going through an entire judgment of say 20-25 pages, you can just refer to the summary that is available online. And but that is only in case where you are in a rush or you are in a hurry to provide judgments, or you have to, there's a deadline to submit judgments. So in that case you can go through these judgments, these summaries, which will help you to, of course, if in the summary you find one particular judgment or a particular point relevant to your case, then you can go through the entire judgment. But basically if you have these summaries handy, then you will not have to go through 15-20 judgments in entirety to look for the appropriate judgment which will suit your case. This is very important, do's and don'ts while reading a judgment. So when you're reading a judgment, it is very important to have a clear understanding of what you're looking for. You have to understand what is the root cause of filing the case. So basically, if supposingly you are looking for a judgment which you have to cite before a Supreme Court, there can be, on a similar issue, there can be various judgments of several high courts, and these can be contradictory as well. So when you want to cite a judgment before the Supreme Court, you have to see which one will have a binding effect, or will have, of course they will not have a binding effect, but which one will have more persuasive value. So for example, there's a one judge bench judgment of say Allahabad High Court, and a two judge bench judgment of a Bombay High Court. So instead of using the Allahabad High Court judgment, you should rather use the Bombay High Court judgment because it is given by a two judge bench. The next point that you have to keep in mind while reading a judgment is, always you have to keep bare acts handy, and you have to keep the provisions of law that have been referred to in a judgment ready with you. So as for example, the case which I had previously cited in the previous slides, that case was about 354 and Article 226. If you don't have MMC Act with you, you will not understand the reasoning and the provision of law, why it is used, the application of that particular provision, the interpretation of that provision. Now, a lot of judgments are only based on interpretation of a particular provision. To understand that interpretation, you will have to first read the relevant provision. The next part is that, and this will obviously only come with time, you have to skip the trivial aspects in a judgment. So, for example, when you're reading a judgment, you have several facts which are repetitive, and that is usually done maybe because the parties have in their contentions or while arguing, they have repeated facts, and those facts are in the judgment itself, in the body of facts earlier that was cited. So you have to learn to skip through those smaller aspects and to go through to the main part, the reasoning or the application of law, the interpretation of law. And obviously, the main thing that you're looking for is the ratio decidendi. So what was finally upheld or what was held by the court is one thing which you're looking at. Only if that is in your favor, then you will go through the entire judgment. Now, the next important thing, and this is the most important, I would say, is making a case note. So basically, throughout your legal career, or maybe while you are a law student, you will go through a lot of cases. And each time, instead of referring to that particular judgment in entirety, if you have a case note ready and handy, it will make a lot more easier for you to, rather than reading the entire judgment, you have a small 2-pager or say 5-pager case note. You have to refer to that only, and that will give you a brief idea of what the judgment is. When you're looking at don'ts, you don't have to rely only on the head note while reading a judgment. So if you see these online portals like Manupatra, like Supreme Court cases, they have case notes, excerpts, all of these things for a judgment. But most of the times and very often, it is that these head notes or case notes do not have the facts or do not have the provisions which are very crucial for the judgment. So, in order to arrive at an overall understanding of the judgment, you will have to read the judgment fully. Of course, like I said earlier, you can skip the trivial aspects, but don't skip those portions which, because many a times when you are in a court of law, when you're before the judge, even a single comma or a single word can change the meaning of the entire sentence. So, when you're reading the judgment, you have to be very careful about all these things. Then the next point is you do not have to read every text in the same manner. So for example, in the body of the judgment, there is a legal term that has been used, or there are facts which have been cited. And similarly, in the later part, there are similar sentences or texts. That does not mean you read the later part similar to what was read in the initial paragraphs, because you cannot read a judgment like you're reading a textbook or like you're reading a novel, because you have to analyze, you have to understand, and while you're analyzing, you have to critically think about why the judge has arrived at a particular conclusion. And for this, you don't have to have a biased mind while reading the judgment. So there a lot of times you may come across judgments which are on a social issue, or maybe an issue which you are very close to. So supposingly, for example, I can tell you about stray dogs, the recent judgment which was passed by the Nagpur bench. A lot of people, while reading the judgment, will get sentimental or will have their emotions playing while reading the judgment. But you do not have to have a biased mind while reading any judgment, and that is because each judgment will have its own reasoning. So when you're reading the reasoning along with what was held, you will get a complete understanding of the judgment. The next very important point is that you don't have to jump to conclusions. Now, for example, if in the contentions of parties in the judgment, it is said that, okay, this particular case law, they've cited a case law of the Supreme Court, and they've said that, okay, this particular case law is similar to our case, and therefore the judge should deliver the judgment in our favor. But this does not mean that there cannot be any later judgments which are passed by the Supreme Court itself. Therefore, to have an overall understanding or to understand the judgment, you have to read from the first para till the last paragraph, and you have to see how the judge has arrived to the conclusion that he's arrived at. Then the next, as I said earlier, you don't have to skip any part of the judgment, because sometimes even punctuation marks, even a single sentence plays a very important role while deciding or while holding the persuasiveness of the judgment.
When Ruchi said don't rely on the head note, it's important to keep in mind that no judge themselves ever makes a head note. So these head notes are actually made by the publisher, either SCC or Manupatra or AIR. Now they are using it only as a reference point. As in case they say XYZ has been held in para 21, then when you go through the judgment, para 21 will state that. So therefore, the head note itself is not something even in court you will actually rely on. You will ask the judge to basically open that particular paragraph and read the entire thing. So moving on. Now, how to move towards reading a lengthy judgment. Now, when we spoke about the challenges to a judgment and we said about how this platform might mainly be law students, and the length is something which obviously is the first thing that causes this daunting task that happens. It's important to understand that to make the process easier, there are certain strategies and like ways in which you can actually go towards effectively reading a judgment, which is as lengthy as it might be. This obviously will come with time. And it goes back to what Ruchi said about skipping the trivial aspects, which obviously will be more helpful. So first point can be you start by skimming the text. Now, skimming in general, even if you're studying some chapter in school, there are certain parts which if you just do a quick read through, you might be able to understand it better, or then read it again in more detail and understand it properly. So that can be done even for a judgment here. Because if you start reading, say, a lengthy judgment and you go on the facts of 5 pages and you start reading that to the point to try and learn it or remember it, it may not be that necessary, because if you're just using it for persuasive value to argue a case, you need the final decision at the end as the main thing for your actual argument. So by skimming the text, we mean you can quickly assess what type of documents, as in what here it wouldn't be what kind of documents, it would be what kind of precedents, what kind of arguments they're actually dealing with, and how the judgment as a whole has been structured. Now, if you look at even Supreme Court judgments of today's day and age, there is a lot of talk about how Justice Chandrachud's judgments are very well structured or very well researched. And you'll notice that each and every judge has a different way of writing their judgments, which is why even if there's say a constitution bench of 5 judges or more, the actual author of the judgment is specifically mentioned, because that is the way in which a judgment might be structured. So if you skim through the text as a whole, you get a general understanding of what is being said, and then you know two things: either where you need to focus attention, or what you probably need to read a second time to actually understand better. Coming back to again breaking the text into sections and subsections, this is in a very simple way how to manage to read a long judgment. Your long text can be intimidating and hard to grasp. So you take a few moments before beginning to read the whole thing to break it down into smaller pieces to make this process much easier. Now, this again comes down to probably reading the head note first, to at least when you're understanding the judgment for yourself. You read the head note so you know what exactly this judgment is dealing with, what exact point of laws are there, and then through that you can divide it into, say, because a judgment might actually deal with 4 points of law in one judgment itself. Like the example we showed, it had a constitution article as well as a provision of the Mumbai Municipal Corporation Act. So in that sense, the head note, it didn't have it in this particular reporter, but another, say, Manupatra or something, if we had taken, it might have had head notes. So we would know exactly which part of the judgment is dealing with what point. And that is a way in which you can break it into sections and subsections. And of course, over time, you will figure out how to leave the trivial aspects and go through it much faster. Then, of course, now while reading a lengthy judgment, if I say the next point that you should read each section carefully and with attention, it might seem to be more daunting as a task because you actually have to go through everything carefully. But what we mean here is actually in relation to the second point. Once you've broken it into sections, then you go through each section more carefully. And that attention that you like, the detail to attention that you might have at that point of time, will help you actually understand each section properly. So the entire judgment would then make sense to you. So as we've said, even if one starts by skimming the text, you have to read each section in detail to not miss any key point or argument. And of course, this will require patience and discipline, which might come with time. But in the end, when you actually need to argue a judgment, you need to know the entirety of it. And a personal example, for example, we were in court once, and there was a particular person, an advocate, who was arguing, and he read the final conclusion. But the judge categorically denied him any relief by stating that the facts of this case are entirely different. So even though he had a particular point of law completely in his favor, the reason that previous precedent was set that way was because the factual matrix was different, which is why the law was laid down in that way. So in that sense, it's important to know each section properly. You cannot just, as in, for example, when you're doing moot courts, it might happen that when you actually find a judgment which has exactly your point of law, you want to put it in your memorial, stating that this is completely helping. But then you might not see that the reason that judgment is given is because the facts were actually entirely different. So in that context, you have to keep in mind each section carefully and with attention. And again, you take notes while you're reading, so that, of course, you have the important details ready, your arguments ready. And you'll often see even like the most senior counsels, they'll have within one judgment, they'll have a lot of like post-it notes, flags put in to actually figure out, a lot of underlinings, a lot of arrows going from here to there to like try and figure out a correlation between the paragraphs. So that is something which is basically a lifelong process. You can't read a judgment without making notes. That's usually never going to happen, which is why even if, say, we're reading it on a laptop, you will highlight certain points. You will probably make like some written comments somewhere. And that is required as strategies, all these 4 points, which might help you to read a lengthy judgment in a more effective manner. Going forward with how to prepare from a judgment, this means how to prepare a case analysis. Now, the way in which we've taken this particular topic is understanding that there may be many law students and you have to prepare a case brief or you have to actually prepare a case note, or even if you're giving a presentation, for example, on a particular judgment, what very often might happen is you're totally confused as to what points to keep in, what points to leave out, how to explain the whole case, and whether you've understood the case or not in the first place. So, of course, a case analysis after a judgment will require preparation. Now, you may have the entire case with you, like the 30-40 page document, but to make an analysis or even say argue in court or present the case before the class, probably through a PPT or something, you would need to one, break it down, and two, of course, put it in simple language so that people understand it, because the judgment is there for everyone to read. If you're actually analyzing it and then presenting it, it needs to be in a little more easier format to actually go through. So simple things to keep in mind how you can do this is you read the judgment carefully, you research the relevant law, because even if you're preparing a case note on say XYZ judgment, more often than not, your research will also include some other judgments which have held the same point, or whether this judgment has been referred to in other matters, and so on and so forth. So that comes to researching the relevant laws. Then, of course, you analyze the judgment, you draft your summary, you present your conclusions. Now, for example, if you're writing a research paper on a particular point of law, even though you may find a lot of judgments stating that exact point of law, at the end, you will give a conclusion of what you feel the entire matter is, or probably a conclusion might also be limited to how the High Court or Supreme Court has actually held in whichever way you're writing the research, like whichever side you're writing the research paper for. So, in that context, coming to the first point, of course, you slowly and carefully make sure you understand each and every aspect or sections, or you look at arguments that are made for or either in the entire judgment itself. Then, researching the relevant laws, it's very important to understand how I said before that a particular point of law may be decided, but the factual matrix is different, which is why we put this line that it helps you to understand why the court has reached its decision and what legal arguments could be made against it or in favor of it. And going back to Ruchi's points of the elements and how she made a statement that a particular counsel's arguments within a judgment may be read, and that may still have another, as in the judgment which they are referring to, might be overruled or cited differently in other places. This comes down to actually when you're reading the entire judgment, if you find a particular point of law in the middle of the judgment, as in if it's an argument which is made by one of the counsels of either sides, and then you put that in. Now, you might use that precedent to say your point of law, but whether or not that point of law has actually been taken by the judge in this decision itself is something you'll only find out at the end. Because, of course, both sides will make their arguments strongly, both sides will have their judgments ready. But that particular judgment you are reading has a decision at the end where only one of those things has been ruled as correct. So, therefore, if you're citing that judgment, you cannot use the precedents which have been actually made reference to by the counsel that has actually lost that case, because then that judgment has held against those arguments. So, that has to be kept in mind while you're analyzing the judgment and researching relevant laws. Then, drafting your summary. In short, if say I mean, the judge will ask you to explain the case in like a few lines. Now, of course, that is something which might completely put you off guard. But if you've understood in general, like for example, even if you're arguing a case or you're arguing your moot courts or ADR competitions or whatever, the problems might be running into multiple pages. But of course, if somebody asks you to explain in a brief, you will be able to, because the entire factual matrix or the entire history or correspondences between parties may not be that necessary to actually state in short when you're explaining in brief what the actual matter is. So that way a summary always helps. And of course, you in this you should include any implications that your case may have for future cases and how the law in general may actually be affected. And when you're finally presenting your conclusions, this is, we've obviously mentioned it, presenting them to a judge or either legal professionals, but for law students it might be probably in a presentation in class or something like what we are doing right now, how we've also like analyzed everything, put it into PPT, and we're explaining it to you. So in that sense, you have to provide clear and concise explanations for why you believe that the certain arguments used is actually in your favor, and why the arguments which have been discarded in that sense are against your case. So in this way, you can again explain how this case may affect similar cases brought to the court in future, what implications it may have for the law in general. Like for example, if I take a very random example of say the fourth schedule of the Arbitration Act, where the arbitrators' fees have actually been fixed. Now, the Law Commission report which gave it actually made it it wasn't a mandatory provision. It was more of a reference point which could be used. but a recent Supreme Court judgment of ONGC has made it mandatory. So now, in that sense, there's a lot of confusion with respect to this entire point, because many smaller cases, as in value being small, there aren't many arbitrators willing to do it because there's been a cap put on. So if you are arguing your conclusions, and this last point of how this case might affect future cases or the law in general, that also has to be kept in mind, because even when you're arguing your matter, you know that the judge is going to give a decision. So that decision, of course, will be held as binding for future course, until and unless, of course, it's overturned. So while arguing your matter, also you have to be aware of what your arguments could lead to, or how it could actually cause a change in the entire legal scenario.
There are a few recommendations from our side for effective reading of a judgment. Now, as we have already stated that when you're reading a judgment, it can be really mind-boggling as to what to read, or from where to read, or from where to find a relevant case law. So those who are not very familiar with legal terms or with legal provisions of law, then that can be very much challenging. So, therefore, in order to read judgments effectively, there are certain points which have to be kept in mind. The first is that you have to read the judgment with the context. That is, when you start reading a judgment, it is very important to read the facts first, in context of which the judgment is given. Like Yazad has already pointed out, the facts can be different in each for each judgment, but the provision of law can be the same. Therefore, if you don't read the judgment or the final ruling in context with the facts, then that can lead you to a very miserable situation, because if you are reading a judgment and by reading those particular facts, or by reading those particular provisions of law or judgments or case laws, you do not know why this provision of law or case law is stated, then that will not, you will not be able to have a comprehensive understanding of the judgment. So therefore, for this, for reading the facts or reading the judgment in context, it is very important that you first read the facts or the relevant things which are like the elements of the judgment, which I have previously referred to. And then you break down the judgment. Now, breaking down a judgment into these elements, like for example, the ratio or the obiter dicta, or supposedly the submissions of parties, will make it very easier to manage how these sections are correlated, maybe, or how a particular paragraph or a particular ruling might turn out to be in your favor. So, if you're breaking down a judgment into these components, you may skip through a certain those broken down points and read only the relevant points. Therefore, while breaking down the judgment this way, it will help you better understand the how the court has come to one particular conclusion. And therefore, see, if you read the arguments only and you don't read the facts, or if you read only the ratio decidendi and not the reasons or the obiter, or maybe you do not read the reasons or you only read the final verdict, then that will not help you to understand how the judge has interpreted a provision of law, or how the judge has applied one particular case law to the facts of your case, that the judgment of the judgment that you are reading. Now, the next point is that you take notes while reading a judgment. Like already stated earlier, taking notes will help you keep track of the key points and arguments or the provisions of law. Now, for this, what you can do is basically you can highlight the important paragraphs. If supposingly you're reading a PDF version of the copy online, then you can use those tools, those highlighters, to mark the relevant paragraphs. And now, obviously, with the advent of technology, there are a lot of AI based apps which will help you analyze judgments. So I cannot obviously comment on how reliable those apps will be. They will have to be tried and tested, of course. But these tools also will help you read the judgments quickly and they will give you like a gist or a brief summary of the judgment. So that will increase your productivity, of course. So instead of reading one case in say 20 minutes, you will be able to read 3 to 4 cases in 20 minutes. Only the summary, I'm saying, not the entire case, of course. And if you find the summary to be helpful, then you can go on reading the entire judgment. And that you can do carefully, then. You can give sufficient time to reading the entire judgment. Then, as you're reading through the judgment, you look for trends. That is, you look for the court's reasoning, you look for the court's decision. This will also give you a fair idea of how such kind of cases are decided in similar situations. And you will be, so after going through all these points, after going through all these elements of a judgment, you will get a fair idea of what the judgment is about. And of course, before going through the judgment, you will have to identify the purpose why you're going through that particular judgment. Only if you've known the purpose of reading that judgment, you will it'll fructify into some better result. So then these are some tips which are from our side, of course, for effective reading of a judgment.
Keeping in mind, see, if you've noticed, there are a lot of points which have been repeated. For example, taking notes, keeping each section and understanding each section in a proper context. We've added this looking for trends basically to understand why a court decides in a particular way. To add on to this, it's very possible that you see when you're actually in practice that there may be a particular judge who does decide matters in a particular way, whether it comes to the assignment given to them or the way in which they hear the parties. And this is not saying that any judge is biased or anything, but it very often does happen. As in, you can figure that out when you're actually in your litigation practice, that there will be a particular judge who may be a little bit more lenient on, for example, the government trying to actually take steps to actually have effective measures done. If the judge, there may be some judges who are very hard on developers. There may be some judges who are a little easier on developers and give them a second chance or a third chance. And that depends on the trend in that particular court, the way it works, the way the decisions have been given. Which is why, just as a random example of Bombay High Court, when Justice Kathawala retired, everybody stated that the developers will heave a sigh of relief because he was known to be a very hard taskmaster after the developers. And that is a particular trend in that court. Now, that doesn't again say that the judges currently are not that hard on the developers. It's just a different way in which he would probably be hearing the matters.
How do you know if a particular judgment has been overturned or not?
In general, if you're actually searching on something like SCC or Manupatra or a particular website or journal that has been made for this, they very often have a particular icon which displays whether it's been overruled or not. Now, I'm not getting into the exact details of what it is, but say, for example, on Manupatra, there may be a green circle over there, which means that this is the current actual precedent to be used, and it's not been overturned. In that sense, what you could do as a very easy measure is the judgment that you actually referred to. If you want to see where it has been cited or whether it has been cited more, you can do a simple search of that judgment and you will actually find out judgments in which it has been cited. So if you find a particular for like later on judgment which cites this case but holds differently, then automatically you've understood that the judgment has been overturned. And this is only to keep in mind that if you're actually arguing in court, for example, you may have 100 judgments in your arguments, but if the other side finds out that they say 50 of them have been overturned, then those 50 judgments are basically gone for a toss because they aren't helping your matter in any way at all. So that way, it's important to know whether your judgment is the final verdict or not.
The next query is how to remember more than 4 to 5 judgments for preparing a moot competition. How to remember, how to memorize.
So when you're preparing for a moot court competition and for those preparations, you are going through those judgments. Like I said, you prepare notes of say maybe one page of if supposingly the judgment runs into say 10 pages or 20 pages. And if you have like a 1 pager note, which has crucial points or provisions of law maybe, or the arguments which are in your favor. So supposedly in a moot court, you will be given a side, either the petitioner respondent or the appellant respondent. Now, if that particular judgment, if supposedly there are 4 to 5 judgments in your favor, you will have to see how the facts of your moot proposition can be correlated with those judgments. And then with that correlation, you will be able to, memorize, or it'll better be there in your mind if you're going through it like that. So you have to correlate the facts of your moot proposition with the judgment. And while you're going through the judgment, you also have to read the facts which are cited in the judgment. If they are different, obviously you cannot use that particular judgment for your for advancing your arguments. And for memorizing, then you can take notes, and maybe you can go with your brief which has notes on all these judgments. It is not that while you are arguing in a moot court competition or even before court, that you cannot carry your case brief or you cannot look at any particular judgment. So always, like, if you also carry a copy of the judgment and you have the important provisions marked or highlighted, it will help you.
In any case, your moot court or your actual practice, it's not an elocution type of thing in which you need to memorize and then speak. You always have your reference point, your acts are there with you, the sections are there with you. Same way, your judgments are also there with you. As we said before also, a lot of senior counsels you can see when they're actually arguing, their judgment brief which they have will have a lot of post-its in it, a lot of flags made, a lot of markings made. So that basically tells us the exact same thing, that it's not a rote learning process where you have to know the whole thing and speak. You have your reference point, but of course it cannot be something where you're actually reading through the whole thing. So in that sense, you have to have a rough idea of it, but there is nobody who said that you have to memorize the whole thing.
How is reading a judgment helpful in writing a judgment, and one should take part in these kind of competitions? Please share useful tips for the preparation.
I mean, personally, I've never done a judgment writing competition as such. I'm not sure if Ruchi, I mean, I had not heard of this, to be very honest, when I was in law school. But I mean, I'm guessing a judgment writing competition, if you keep in mind all the elements that we put in, whether it is the quorum, the party names, the actual jurisdiction that is there, the facts, the issues, the legal submissions, obiter dicta, ratio decidendi. If you know all of these elements and you have a particular factual matrix before you, and you've done your research to figure out which side, like which party basically has a better case as per the law, then keeping all of these things in mind, it should not be difficult for you to actually note down the judgment. Because effectively, a judgment in every essence of it is the factual matrix plus the arguments made plus then the decision. So the only aspect which may be difficult in a judgment writing thing will be to figure out what decision has to be given and how to actually state the facts as per that decision. So that is something which obviously might come. I mean, I can't say it comes with time, because until and unless you're actually a judge, you're not going to write your judgments. But at least for competition basis, what you could keep in mind is that you can, like, one, definitely practice. You could probably see a factual matrix. You could actually use a precedent in this also. If you've been given a particular topic which has like 4 or 5 pages of facts, you can do your own research to find similar cases that have been dealt with before. See how those judgments have been written. Try and basically not directly lift off it, obviously, but use that as a reference. And in any case, it comes down to the exact same way, similar way in which you actually make your moot memorial itself, in which you're putting your facts down, you're putting your submissions down, and you're putting your decision at the end. And of course, then in a moot memorial, since it is the actual pleading, you're putting it as a prayer, and it's one side each. But in your actual judgment writing, you will have both sides' arguments and then your decision at the end.
While you're writing a judgment, I think very often your judgment and reasoning will be in correlation or with respect to one particular issue. So maybe there are 4 issues supposedly to be dealt with in your judgment. Each issue will have a separate answer and a finding to it. Now, while you're writing this judgment, you also have to write the reasons of how you've arrived at this particular conclusion. Now, for that, you can maybe use the provisions or, provisions of law that have been cited, the facts, and relate them to the provisions of law. You can also use, like Yazad said, you can use the precedents that have already been, set by the judges or that have been provided to you. Now, each particular issue, when you're writing a judgment on each issue, you have to keep in mind that each issue will be different and the reasoning for the same also will be different. Therefore, you cannot cite the same provisions of law. Maybe, of course, if it is relevant, you can, but for each issue, you will have to look at a different perspective, look at it at a different perspective. And that's how you will write a judgment after going through the facts, the reasoning, the provisions of law, and the judgments.
What is the difference between reportable and non-reportable judgments, and how to find non-reportable judgments online?
Generally, when you're going through a judgment, on the top corner you will find either a judgment is either reportable or non-reportable. Now, generally, why a judgment is said to be reportable is because maybe the judge wants to set a precedent with that particular judgment, or if there's a substantial question of law which has not been previously decided, or there's a question of law which has been previously decided and maybe the judge wants to overturn it. Then in those particular cases or in those judgments, the judge will say, okay, I want to make this judgment reportable, and therefore you will find this reportable judgments in the law reporters later on. Now, for a non-reportable judgment, you can either refer to the non-reportable judgments on the very website of that particular high court. Say, supposingly, you know that one judgment is being delivered by the Bombay High Court or by, say, the Allahabad High Court, then maybe you can go on that particular portal. If you know like I said, the case number is very important. If you know that, you can fill in the relevant details and you will get a copy of that judgment as well.
Reportable judgments only have that little extra binding value. Like as Ruchi said, it's probably, it is the judge's discretion about whether to make it reportable or not. And that's obviously based on their experience of the holding that they're actually delivering. So that's the only difference between the two. And how to find it out is, of course, through the basic court website itself. All the reportable ones will be on all of these portals, SCC, Manupatra and all, which come in those final volumes, and non-reportable ones easily from each particular court website.